case of Mrs. Haberkamp versus DeAndre Searcy.
David Fainter on behalf of plaintiff. We were just...
All rise, because this isn't your everyday eviction case. We've got overdue rent, Section 8 housing on the line, and a tenant who's finally ready to speak up. The big question, will this play out as justice?
This one up.
Okay.
So here's where I think we're at. I think we've got an agreement. The amount of rent that's owed is $4,223. There's $175 in court costs for a total of $43.98. He's got $275 right now, but it's on his card. So he's going to turn that into a money order and drop it off. And this is the address you're going to drop it off. 206 North Huron. Take this. And then what he's going to do starting in June, he's going to start paying on the 5th of the month, $750 per month. His rent is basically $275. So by paying the $750, the first $275 will go to the rent, and anything over and above will go toward the arrearage. It'll take a while, but we'll work with him. He's lived there for a while. He's on Section 8. And this was the deal that we talked about last time.
Right.
And so I just need him.
Or just another tangle of red tape in the system. Here's where it gets tough. The rent is only $275, yet the tenant agrees to pay $750 a month, nearly triple, just to dig himself out of debt. Is this fair, or is it desperate?
To sign this conditional dismissal. And right there. And then the court will inform you of your rights.
Do you have any questions regarding anything on that conditional order dismissal, sir?
Yeah, you didn't tell me how long my lease up, because man, I'm getting tired of what I'm staying with. They don't fix nothing, and we still got people laying in the hallways and everything. It's just a whole bunch of harassment. They hassle me over this money where it's been over like 3 or 4 landlords, and they don't get in touch with nobody. But right now, Section 8 on them because they not fixing my place, and Section 8 involved and they trying to kick me out, and I'm like, they didn't even fix it when they got to fix for me to even pass my eviction to check the house.
Operation in motion. That's rent court for you, where every payment plan feels like a cornered deal. Now the tension really surfaces. He's not just behind on payments, he's stuck in a broken system where landlords ignore repairs, squatters take over the hallways, and Section 8 pressures him from all sides. How do you catch up on rent when no one's fixing the place you're paying for? The judge steps in and seals the deal.
Okay, so do you want to enter into this or no?
I do, but $750, that's a lot. That's all my whole Social Security.
This is the same thing he did last time.
I'm okay with it, but I'm just putting suggestions out there. Because, I only get my Social Security is only like $645. Then I get $112. Then I got my tickets I paid off. I got to find where to do the yard work for that. Washington don't do that no more. I got all this stuff on. That's just like, it's okay, I can pay it, but I think that's too much. Even where I had to find a landlord and I got people on my side.
But it sounds to me like you're not agreeing to this.
I'm agreeing to it. I got to. I ain't got no choice. I can't be kicked out, but I just think, what I'm saying, everything ain't my fault.
Your Honor, may I?
Yes.
Last time we were here, he complained about money that he thought he owed when Beal managed.
When I'm telling you now.
So I took that off. We got management back, MTH did, in December of 2023. Since that time, there's 18 months. He's made exactly 3 payments.
Because I didn't know who to pay it to. They didn't tell us when they switched landlord. They didn't tell the whole business, we doing switching landlord like a business supposed to do. Here's the note on the door for everybody.
If you want me to enter this, then I will. If not, and you're not in agreement, then I won't enter it. And I'll set it for trial.
But if we have a trial, it'll be a number and he'll have to pay it, because this is what happened last time, which is we came to an agreement and then we got to the podium and
I would say I'll do an agreement. I'm just saying, like, I just want to put my point across. I got the right to speak, but I just think, I'm gonna pay it. But
okay, so you want me to enter this conditional order dismissal?
He ain't gonna bring it down no more.
Have any questions regarding anything that's on?
No, that's it.
All right. I'm going to sign off on this.
Just make sure you can't.
Be business.
But with a twist. The tenant has 3 days to challenge it, almost like signing a contract while keeping one hand on the emergency brake. Will he make a last-minute move, or simply hope for the best?
Days to think about this. If you believe that there's some legal reason, some right you didn't assert, or some confusion on your part, you'd have to file a motion with the court within that time frame. That doesn't mean that I would set it aside, but you have that time to do so. You understand that?
Mm-hmm.
Okay, thank you.
Thank you, Mr. Sears.
Mm-hmm. So it's 206 North Huron?
Yes.
Next case on the docket.
Court calls the case Sycamore Meadows versus Erica Jemerson.
Again, Carrie Zanon on behalf of plaintiff.
There she is. She was tucked away and back over there. Come on. Hello. All right.
So, Judge, I just received the ledger as well. On this one, I'm showing $3,726. Court costs of $190. So the total is $3,916. Ms. Jemerson, did you?
That's not true.
Okay. How much do you think you owe?
The judgment that you signed was for $2,400.
Oh, this is one that we've been carrying over.
Yeah, and then my rent is $0 since 2024, so $37. I don't know where that came from.
Okay. I signed that judgment that I signed back in. When did your rent go to zero?
September of 2024. They just making up numbers.
Ms. Jemerson? No.
All right.
I'm showing that she's $63, Your Honor.
Pardon?
I'm showing that rent is $63 for Ms. Jemerson.
Okay, but even if it's 63 as opposed to zero, I think what her point is how do I get to 30? What was it?
3,700.
Understand, Judge.
To 39.
Case number 2 comes with a plot twist. The tenant insists her rent is zero, but the ledger says she owes nearly $4,000. How do you pile up thousands in debt when rent's supposed to be free? Either the math is wrong or the paperwork's a mess, and now it's turning into a full-on numbers showdown.
Just so that clear, how do I get to 3916 when in February there was a judgment for 2414?
Judge, I will, can we adjourn this 1 week so I can go over the numbers with my client? And then I will hopefully have
I'll adjourn this then to March 20,
May.
2000 or 23rd.
You said March. That's why. Sorry.
No, I was staring at the next date
I know.
after the February date.
Thank you.
May 23rd, 2025 at 3 p.m. Okay. And then let them take a look at where these numbers are coming. But I get your point.
I will have.
Okay, thank you.
Thank you, Ms. Jemerson. Don't come in here yelling again. Like that. All right? You come back here yelling, we're gonna have a problem.
Okay, apologize.
You take care. You do the same. Let's call the case of, is it Shakes Corbin or Corbin Shakes? Corwin Shakes versus Bernadette Yacht.
Good afternoon, Your Honor. Nicola Jami, 85399 on behalf of Mr. Shakes. Apologize, my boy. I'm coming off of a cold.
Do that. Hello, your name?
Bernadette Young.
All right, this is a termination case. And where are the parties in relation to this case?
Your
have no
Honor,
idea.
Mr. Shakes is on via Zoom right now. He lives out of the state.
Yes. All right. There was no lease on this premises.
No, Your Honor.
All right.
The notice was mailed to her on March 5th. We gave personal service of the complaint on April 22nd. We've given way more than enough time that's necessary under the law. We would just I'm ready to proceed with the hearing on this matter if it's necessary.
Well, except for the fact that she's a tenant at will or by sufferance. And I don't have the proof of service copy of the notice to quit, but you've indicated that notice to quit was mailed on March 5th.
That should have been in the packet.
But Okay, it's not there, but that's okay. I have a copy of the notice to quit, but not the service copy. But based upon your representation that it was mailed on the 5th, there's a problem because it indicates that she has to move by March 30th, which would mean she was not given 30 days.
Wait, hold on, hold on 1 second. We didn't file the complaint until April 22nd.
Oh, right.
Like I held off on
I
filing
get that.
for that reason.
Pardon?
We held off on filing for that reason.
Well, that doesn't correct the notice. I understand you may have held off filing, but that doesn't correct the notice. The notice has to give 30 days. And the notice has to be proper for this court to have subject matter jurisdiction. The problem is, by not doing that, I don't have subject matter jurisdiction over this at this point. And when I don't have subject matter jurisdiction, my only option at that point is to dismiss.
Well, wait 1 second, Your Honor. Hold on a second. Let me just clarify something very quickly. Because that doesn't sound correct. Your Honor, can we have can we pass this very briefly?
Sure.
Thank you.
Ma'am, I'm going to pass the matter, so you can have a seat. Then I'll call you back up.
Okay.
Okay, thank you.
Yes, Your Honor. Nicole Jami, 85399, again on behalf of the plaintiff. Your Honor, I see where the issue was. My assistant had sent it over to be delivered personally on the 28th, which is the date I authorized it to go. Did not mail it until Monday the 3rd. So the notice, yes, is off by 2 days. There's 28 days. However, we did not file this complaint until April 15th. We have email communications with Ms. Young about, she knew, like she was emailing back and forth stating, I received your notice. Please give me more time. I'm looking for housing. And again, I know the notice is defective, but please ask this court to recognize that she had noticed, she was communicating with us. My assistant had sent out, I'm sorry, I already said that, Your Honor, and I would just ask this court to please allow that.
Yeah, no, I hear you, counsel, and it would be an
Can we
invalid
amend it and can we adjourn and amend? Can we do that?
That the one thing that really cannot be corrected is the notice, because that time period has to run prior to the filing of the complaint, but the notice has to, no, hold on. But the defendant has to have that time period in that notice. Right? So otherwise, quite frankly, from a practical standpoint, you would end up with 2-week notices to people because people can't get before the court till X time in any event. But so you have to give them a 30-day notice, then file. I understand, I think it may be a day, it may be 2 days, but that's the only way that this court can assume subject matter jurisdiction over the case, is by the filing of a proper notice statutorily. So,
I understand.
All right. This being the case, the court lacks subject matter jurisdiction. This case is dismissed. Ma'am, I would assume, so that you know, I'm dismissing this case. It's without prejudice as to the issue. So my assumption is that they are going to begin these proceedings again. So they're going to be back. Okay? All right.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you, folks.